Kalui. I should have looked at that before this morning. Counsel, as you know, each side is allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal, but if you do decide to reserve time, you're in charge of keeping track of it for yourself. The clock on the podium will reflect the total amount of time you have remaining, including what you might have decided to reserve. We record these proceedings, so we'd be grateful to you if, when you approach the podium, if you would give us your name and the name of your client as well. We've read the briefs in the case, we've examined the record, and we've also discussed the case among each other in a conference this morning. So with that, you may proceed.
Thank you, Your Honor. My name is Keith Kanako. I'm here on behalf of Dr. Harvey, the appellant in the case. Rule 8.6 provides that if a court determines that a time limit established by Rule 8.2 has been violated, it shall, on motion of the defendant, dismiss the prosecution either with or without prejudice. In this case, there is no dispute that the 8.2 time limit in the case expired.
Can I interrupt you, Mr. Kanako? Because one of the pervasive issues I see with this case is the lack of an adequate record from the municipal court. And when I look at the transcript from the hearing before the Superior Court, there are contradictory assertions by counsel about what happened in the municipal court. The prosecutor argues at one point that the municipal court judge didn't believe defense counsel's explanation about, I didn't lie in the weeds, I didn't know about this, and therefore, as a sanction, excluded time. Your colleague said that's not true. The court kept saying, I don't have a record, I don't know what happened. What are we to do with that?
Well, you would have to go based on either what was not disputed or based upon what the record shows. And there is no record of any finding that my associate, Mr. Smith, misled the trial court. There was a suggestion that there could be an inference drawn because the motion to dismiss was filed several days afterwards, but you could draw the same inference, I suppose, if you would draw an inference simply from the delay, that the prosecutor intentionally misled the court too because he didn't raise the issue, or that the judge was somehow trying to deprive the litigants of their speedy trial rights because he missed the issue.
But we have case law that tells us how we decide something in the absence of an adequate record, which is we presume it supports the ruling of the judge.
Well, but here, I guess, what factual inconsistencies did you note in the oral argument? I could respond to them specifically.
Well, the one that I just mentioned, if you look at the transcript starting on, well, I don't know the page, but the prosecutor, and I'm sorry, I don't know if it's the same counsel for the state as here today, but argued that the municipal court judge was upset and said that the court found it hard to believe your colleague's assertion that we didn't realize that the time limits had expired, we weren't intentionally delaying. And so the representation before the Superior Court was that the municipal court judge found that difficult to believe, and that as a sanction under Techie excluded time. Your colleague then said there's no record of what the prosecutor just said, and therein lies the dilemma.
Right.
And the court twice expressed concern that there was no adequate record and talked about, in the absence of a record, I have to presume that the municipal court judge did what the law permits, and then later on he reiterated that.
I think what is undisputed is the motion to dismiss was filed several days after the speedy trial limits expired. What I think is also undisputed, and I believe really error has been confessed in this regard, is that even that time was excluded as a result, but even if you exclude all that time, this case still didn't comply with the speedy trial limits. It was a day short. And I think the record is also clear that the reason why there was a conclusion that there was some sort of sanction appropriate was that the motion to dismiss was filed after the speedy trial limits had expired. But I think you can, and that's all the record suggests. There is no other, I think that the record shows that there is no other record on that issue. And the problem with that from the perspective of the prosecution is that if there's a delay, but we didn't cause the delay, or we didn't take any affirmative steps to cause the delay, and the record's undisputed on that point. There are no motions to continue. There were no pretrial motions. Time was never waived. I think all that's undisputed. Then the conclusion can be drawn that under the Tucker case, which we feel is a dispositive case, where the initial trial date was set by the court in June, was the trial date where the trial actually occurred, where there were no motions to continue, and that's undisputed, where time was not waived, and that's undisputed, where there were no continuances of the trial date, and that's undisputed, that would be an adequate record for you to base your decision on, because that would mean that under the Tucker case, as interpreted by the Aguilar case, and then later as interpreted again by the Sprite case, where the whole issue of the Tucker footnote came up again and was not disapproved, there was, under those circumstances, there is no affirmative obligation to bring to the trial court's attention that the limit is going to expire. That's what Tucker says, and the reason for that is that the purpose.
Let me interrupt you, because Judge Carlisle, at the conclusion of his ruling, says, I don't have a record, but it seems that the municipal court judge did rely on, or at least reference Techie, or however you pronounce it, in making his decision. I'm assuming he is aware of it and that he made a decision based on that case, which does require perhaps intentional conduct on the part of the defendant in failing to advise the court prior to the expiration of the time limit. So that's a different pathway from the Tucker analysis that it appears Judge Carlisle relied on, at least in part.
Well, but what is undisputed in the case is that the initial trial date that was selected in June was for October, I believe, 28th, was the trial date where the case went forward. What is undisputed in the case is that there was no waiver of time at any point.
I understand that.
What was undisputed in the case, there's no continuance. So
well, let me tell you where I'm coming from, though. I understand your argument about the motions and how the motions wouldn't have cured a speedy trial violation. But if the court found, if the municipal court found that defense counsel intentionally delayed at X point, we don't know what amount of time could have been excluded. It could have been months.
Well, the conclusion was drawn that Mr. Smith intentionally delayed because he said nothing, because nothing was said. And I think that's undisputed in this case. And so an inference apparently was drawn because he said nothing that must have been intentional. There would be no possibility he might have missed it. But the logical problem with that is that the prosecutor, who's an experienced prosecutor, 10 or 15 years experience with Lake Havasu City, he acknowledges he missed it. And the judge, who's an experienced judge, missed it. So if there's going to be assumed that if there was a delay, if it was missed by all three, that the defense counsel missed it intentionally or deliberately, but of course the judge and the prosecutor missed it inadvertently, then I think you'll have to consider that. But the statement made that he intentionally misled the court was made in that context. And I think that's actually in the record or suggested in the record.
What should happen if everyone just accidentally missed it? What should happen?
If there's been a waiver on the record, if there's been continuances, if there were affirmative steps taken by the defense to cause a delay of the initial trial date, then the case law makes quite clear that the sanctions would be appropriate. But the Tucker case makes clear, too, that if that's not the situation, this is a situation where we went with the initial trial date, there was no waiver time, no continuances, we did nothing to cause any delays, then the Tucker case makes clear that that's not, then defense counsel has no obligation to say anything. And the reason for that is that under circumstances where there are requests for continuance, a waiver of time, or other pretrial motions that cause the trial date to be put back, the Tucker court said in such cases there will always be an issue as to whether the delay was an excluded or non-excluded period under Rule 8.4. That's not our situation. The accused may not lie poised under the Rule 8.2 time limits and then pounce with a claim of denial of a speedy trial because the delay was not excluded time. The prosecution and defense have a duty to request resolution of the 8.4 issue before a speedy trial violation occurs. Well, the underlying purpose of the Tucker rule is that if there's always going to be a dispute over what's excluded or not excluded when the defense engages in conduct that causes the date of the trial to be pushed back, then there's an affirmative duty to bring that to the trial court's attention so that the issue of what's excluded and what is not excluded can be resolved and the speedy trial limits are observed, because otherwise you could have gamemanship that would promote gamemanship. You'd say, well, I'm just going to say nothing, and then I'm going to later contend it was not-excluded. That's not our situation
here. Let me ask you this. Do you think there's any merit here in ordering this to go back to the municipal court for findings of fact on what happened so that we'd have a record?
Well, I think that our position is you have an adequate record to conclude that Tucker applies in this specific factual situation. The speedy trial rights were violated. And I suppose if there's lingering concerns that Mr. Smith lied to the court or something, or said something affirmatively misleading, which I don't think is contended, I don't think he's going to tell you that. I think he will tell you that he said nothing, just as Mr. Yeager said nothing, and that he thinks an inference could be drawn from Mr. Smith's conduct but not his own. But I don't think he'll say that there was any lying. But if that were the issue, then perhaps it should be remanded. But I don't think that's the disputed issue in the case. The inference to be drawn from saying nothing is disputed. We acknowledge that. But the case law makes clear you don't have to say anything under this specific factual scenario.
What's the standard of review that we apply to the ruling of Superior Court?
Well, our research led us to believe it was de novo review, and the Superior Court provided an abuse of discretion standard. In his answering brief, Mr. Yeager did not dispute that it was de novo review, so we think that error has been confessed on that point. Unless we're wrong about de novo review, we don't think we are.
Wouldn't be error, would it?
Yeah, then it wouldn't be error, but I don't think we're wrong. And the other place where I think error has been confessed in this case is that there's an agreement about what time the magistrate, the municipal magistrate, excluded. He excluded 46 days, and the trial occurred 47 days later. So even if you assume that he acted properly in excluding all that time, which we don't agree with at all, but assuming that, the trial still occurred a day late. And the language of the statute, again, in our opinion, makes clear that if the trial occurs late, even by a day, then in mandatory language, the rule provides that the case shall be dismissed, not may be dismissed, but shall be dismissed with or without prejudice. So in that regard, we think there were two places in the briefs where error was confessed, one on the issue of the standard review and the other on the issue that assuming that all that time was excluded properly, the trial still occurred a day late. That issue is not addressed in Mr. Yeager's answering brief.
How do we know that the municipal court excluded 46 days? Where is that in the record?
I believe that you know in the record, I believe it's in the transcript. If I recall correctly, it's in the transcript of the Superior Court proceeding. It's in the argument of counsel. We know when the trial we know how many days the trial occurred late, and we know when the pretrial motions were filed in September to suppress, and we know when they were denied. And then our briefs provide the mathematical calculations, which is all derived from the record. This was discussed before the Superior Court, and unfortunately, it was discussed incorrectly because in the Superior Court, Mr. Smith took the position that it was 4 days late, and then in the briefs before this court, he took the position it was a day late. I don't know how he's no longer with me. He's an excellent young lawyer, but he made a mistake there. As far as I can tell, it was a day late, but it was late, and all the facts upon which that determination is based are in the record and undisputed. And it's simply a mathematical calculation, and it's not disputed. So if we were wrong, you would have expected him to have responded we were wrong in the answer briefs, which he did not do.
Was there oral argument in the municipal court on the motion to dismiss?
I I believe there was. I didn't
Court
handle it,
ruled
but I
from the
believe there
bench.
was. Pardon?
And the court ruled
And
from
the
the
court
bench.
ruled from the bench, and the record reflects Mr. Smith required a written ruling, and the court declined.
But we don't have a transcript or a DVD or CD of that oral argument in the record.
I do not believe that's part of the record, no. And so, in conclusion then, this is not a situation pursuant to Tucker where there would have been an issue as to whether the delay was an excluded or non-excluded period. That's not on the table here. And under circumstances where that's not on the table, then there was no affirmative obligation to bring this to the court's attention. And indeed, there was a suggestion made somewhere that there was some sort of lack of integrity by not volunteering it, which of course assumes that he was aware of it. But if there's no duty to bring it to the court's attention, then as a defense counsel, it may not be even appropriate to bring it to the court's attention. You certainly have to do what you're ethically required to do or what you're legally required to do. As a defense attorney, whether you should be doing anything in addition to that, such as volunteering when it would prejudice your client's rights.
How would it prejudice your client's rights to have a trial set within the time frame?
Well, because if it's not set within the time frame, then you might be able to get the case dismissed.
And
that would, and you certainly have an obligation to speak up if the law requires it, if the case law requires it, but I don't think you do otherwise. And I think that's how most defense attorneys would see that.
But that might be what the rule says.
No, but the rule doesn't say that because it says that you don't have to demand it, and you have no affirmative obligation. The Tucker case makes clear you have no affirmative obligation to speak up unless a pretrial motion or hearing causes a trial to occur later than expiration of the 8.2 time limits.
The Tucker case amends 8.1D in your
Yes.
in your view.
Yeah, and in my view, and I think all the case law is consistent with that, and it went up again in I think it was the Sprite case, I may be mispronouncing that, and the footnote, which the Aguilar case that relied upon, was considered again, and the Sprite case, the second time the Arizona Supreme Court did not modify or correct Tucker. They let it stand, so they've seen it twice. It's the law, I believe, of the Division 2. We believe it should now also be the law of Division 1, and that's the basis of our appeal. I'll reserve my remaining 3 minutes and 41 seconds if anyone has any additional questions. Thank you.
Mr. Yeager.
Thank you, Judge. May it please the Court. Judge Downey, Judge Johnson, Judge Gemmel, I'm Charles Yeager. I'm representing the real party in interest, the state of Arizona. I'm Lake Havasu City prosecutor. I can tell you that I have been with this case since its birth. I've argued every brief. I've participated in all oral arguments, the special action, as well as the trial itself, which was conducted on October 28th.
Can I ask you a housekeeping matter, Mr. Yeager?
Certainly.
The transcript from the hearing before Judge Carlisle, I believe incorrectly has the names of counsel. It has Mr. Osborne as the defense attorney throughout and Mr. Stewart as the prosecutor throughout. That's wrong, right?
You should have a copy of an amended transcript. You're right. I brought that to the transcriber's attention a while back. And
That was the only error. I don't know that I've seen the amended one, but that's the only change in whatever you said.
There was an amendment made, and I was hoping that was submitted to the court for review. But we did catch that and let her know.
Is that the only change?
Yes, she had the wrong names.
Okay.
She had the wrong names. I'm hoping that this court today, basically what we're looking at here is did the Superior Court error in upholding the judgment of the municipal court by finding that the defendant, Mr. Harvey's right to speedy trial was not violated. And we've asserted that his right was not violated from the beginning of this case. We hope to show you, and I think although the defense argues there's no gamemanship involved in this whole situation, I think he opened up the door near the end of his argument, Judge Johnson, if you particularly remember, when he said that perhaps letting the court know about the time limits would prejudice his client. Now, if the goal here is to make sure your client gets to trial within 180 days in this case under Rule 8.2, why sit on that and wait until the time has passed? If you look at the case law in this scenario, if you look at cases like Swevenrud, and I'm not sure if I'm pronouncing that appropriately, the Supreme Court case from 1991, the court says that the goal is to let the court know so that they can cure it, so that they can go ahead and have the trial before the time limits expire. It's not so that you can advise them after. They want to make sure that you are given that trial within whatever time frame is required under Rule 8.2.
But Swevenrud, as I understand it, is slightly different than Tucker, and it doesn't cite Tucker. So Tucker's still out there, and
right.
What's your response to the argument that Tucker changes Rule 8.1D and negates it in this context?
Well, Judge, first of all, as you notice, Judge Gemmel, that I don't think Rule 8.1D requires in all cases. I mean, the state's had a hard time wrapping its head around. We're always finding these comments about Rule 8.1 in footnotes, okay? And I think it's persuasive. Don't get me wrong. It's certainly persuasive. But I don't really see the 1991 decision in Swevenrud changing what Tucker said. And I'm going to get to a point I want to make in a minute on this issue, but I think there is still a goal here, and it's still good law, as the court knows. The Swevenrud case is still good law. But I don't think, I think that ideally you want to have some interference, motions, pending motions, hearings, as Tucker states. But if you look at the language of Tucker, and go back to Spreets. You go back to Spreets. Tucker's a footnote in Spreets. And Spreets is a 1997 case. It says in State v. Tucker, we suggested were cases, whereas here pretrial motions or hearing cause a trial to occur. So in Spreets, it's suggested. It's these recommendations that the Arizona Supreme Court is making regarding the application of Rule 8.1D. I think Rule 8.1D is important, and I've argued it because in the spirit of professionalism as well, and not just because the rule says that they want defense counsel to let the court know. If you look at some of these cases, Judge Gemmel, if you look at, for example, Tucker, the Tucker case, the defendant advised the Attorney General, sent a letter, said, hey, and a copy of that letter was sent to the Yuma County Attorney's Office, and said, hey, let's get this thing moving, okay? And nobody responded. If that was done in this case, if we were advised, and if you look at some of these cases, if we're advised that there is an issue with the time, we are certainly going to take it upon ourselves to try to get the court to recognize that. Perhaps we should set a hearing to determine when we can get this thing on calendar appropriately. As I noted, as you notice in the transcript, I did have several trials set between that period of time. In most cases, you do not have defense attorneys complain about the clock ticking. It's usually, if at all, after the clock has expired, as happened here. And it's very rare, as I pointed out in the lower court.
Well,
Can I interrupt you? Go ahead.
I understand how this could happen, but could you just summarize why we should follow 8.1D rather than Tucker here?
Well, I'm going to tell.
Or is that not your?
Here's my position. I think we should follow 8.1D, but also, Judge, I want to tell you the history of this case. On September, as you know it, you've read the briefs, but on September 3rd, the defendant did a motion in limine regarding Crawford and hearsay, okay? I responded and did my own motion. There was an anticipation on September 3rd that witnesses would not show up by the defense. This is a domestic violence case. And that anticipation resulted in me also doing a motion in limine. The defense then did a motion on the 15th, which 180 days, if we're talking pure mathematical calculation, 180 days is September 11th. On the 15th, they did a motion to quash subpoenas and a motion to dismiss. Okay? I had to respond to those motions. On the 19th, I believe it was, I did I'm sorry, on the 21st of September, I did a forfeiture by wrongdoing motion, okay, which they had to respond. On October 19th, we had oral argument, which I participated in, regarding the motion to dismiss.
Your argument is these are intervening delays that would warrant extension of the date, correct?
And if I could just finish that, one of the things that I want to point out, not just the 19th one, what he leaves out is I had 6 witnesses show up on a evidentiary hearing on the 26th, 2 days before trial, okay, on the motion in limine, forfeiture motion. The judge did not make a decision on that motion until the 28th, the day of trial, the morning, and a written decision didn't even come out till December 3rd. So,
But all that happened after the last day.
well, all of it, not all of it happened. Their motion, September 3rd, was before the time expired. September 11th is when the time.
But would the September 3rd motion have extended the trial date? No.
Well, until the judge ruled on it the judge ruled on it on October 19th. Okay, so there's an argument by them which factors in that 1 day late thing where they're excluding that period of time between the 3rd.
I guess I'm having a hard time understanding why that should have been excluded, why that 45 days should have been excluded, or 44 days.
Well,
because it didn't move the trial date. It was simply
No,
a
it
burden
didn't.
on the judge to rule in the meantime.
You're right, but the problem is when you make an issue of the speedy trial. What my argument has been is now we're at a stage. First of all, you've moved. You're playing a game here. You've moved for dismissal after the court can't do anything about it. But in the meantime, we've got all these motions. We've got oral argument. We got an evidentiary hearing. How would we, even in the best case scenario, been able to satisfy you, even because of these motions? And that's what the law looks at. Are there motions? Now, this didn't cause June 25th. This didn't cause the court to set it for October 28th. It didn't.
I think you're making an argument that's much more difficult for you than you need to make. And
Okay.
maybe I see this differently, but as my questions to Mr. Knakel reflect, during the oral argument before Judge Carlisle, you stressed, and he stressed, the absence of a record from the municipal court. We don't know what the municipal court judge ruled. You, if not stated, certainly implied before Judge Carlisle that the municipal court was upset with Mr. Knakel's associate for sandbagging, intentionally failing to bring this to the attention of the court. And Judge Carlisle talks about how under Techie, which he believes the municipal court relied on, it would have been appropriate as a sanction to exclude time. That's a different pathway from Tucker, which seems to me to be a much easier pathway for you.
And I did argue that. I also argued what I'm arguing here. I touched upon the points that I was just making here. But when I was there, Judge Kalali, he's the presiding magistrate of Lake Havasu City Municipal Court, he did say to Mr. Smith that, that I find that hard to believe. And Mr. Smith's
Response to Mr. Smith saying, I didn't discover this until I was getting ready to file the motions.
Exactly. He said it. There was research. He was doing research. He said, I didn't discover it until I was filing these other motions. And again, this was these motions were filed on the 15th, which is 4 days after the 11th. And the court says, I find that hard to believe. And Mr. Smith's response was basically yes. He didn't really get into explaining. There wasn't back and forth conversation of any further really about that issue, that particular issue. But he did acknowledge that, yeah, I understand why you find that hard to believe.
But if we don't have a transcript of that oral argument, we don't have a written ruling from the municipal court judge, we're shooting in the dark as to whether that judge abused his discretion because we don't know how he exercised his discretion.
Right. And as you pointed out, I think Judge Carlisle, and in fact I have that page 26, lines 10 through 14 highlighted. Judge Carlisle made that assumption that he believes that Judge Kalali at least found some intentional conduct on part of the defendant in failing to advise the court prior to the expiration of the time limit. So, I mean, I certainly agreed with that point that Judge Carlisle made.
Under the legal construct here, is there any role to play by the possibility of prejudice or the non-existence of prejudice? Does that factor in to either
I think it
the city
does.
court judge or the Superior Court judge rule?
Well, here's how I'm looking at the prejudice, and you can correct me if I'm wrong, Judge Johnson. If I look at some of the cases, even Techie, for example, the Division II case, one of the things they looked at was whether there was any prejudice, and they did point out there was no prejudice to the defendant. He was never in custody, okay? And that's an argument that I've made in this case. In Tucker, it says one of the primary purposes of speedy trial is to minimize the possibility of lengthy incarceration before trial. From a standpoint of prejudice to the defendant, that argument gets even weaker when you think about how they played this case. They did this motion to dismiss after the time, and then as the case is making its way to Superior Court, a trial date is set, okay, October 28th. They move to stay the trial. The judge denies it, and we have the bench trial, okay? So they wanted the date to be faster, and then they don't want the date to be on the calendar. And, they want the case to be dismissed. And it doesn't matter if it's without prejudice, because they can't show that the state engaged in any engagementship like Tucker, where the state worked to keep the defendant incarcerated. When they were signing the defendant out in that case, they went ahead and refiled the charges just to keep him in custody. We don't have that sort of scenario. We don't have that game playing here. But what they've worked to do is figure out any way that they can to just get this case dismissed even temporarily. And you'll notice in the brief that they say, well, it's immaterial. It's immaterial whether the state will decide if it's dismissed without prejudice, whether the state will refile or not. Well, isn't it I'm confused about what they think the goal of getting their client to have his day in court is, when they would be willing to sacrifice this case getting dismissed and refile and starting the clock over again. I think it is material. I think it's important because, if you want your client, this is a procedural right, it's not a fundamental right, and you want your client to have his day in court, but you're willing to just play this game to get it dismissed, see what happens, roll the dice. Maybe they won't refile. At least you can tell your client, I guess, that it's dismissed, even if it's for a day. So I'm just really kind of disappointed in the way that this case has been handled throughout the lower court, as far as the procedural movement of the case.
Let me ask about our standard of review. What is our standard of review of the Superior Court's ruling?
Well, they cite a case, Wassenaar, which is a Division I 2007 case, and in that it says that trial court's ruling regarding Rule 8 will be upheld unless a defendant shows both abuse of discretion and prejudice. And I guess I'd have to go over that case again because I haven't reviewed it in a bit.
But that would apply to the Superior Court's review of the municipal court. We have a very clear case, Home Builders Association, that the Court of Appeals reviews the Superior Court's decision to deny special action relief for abuse of discretion. So the trial court in this case is the municipal court. The Superior Court follows a standard you just mentioned, but ours is abuse of discretion of the Superior Court's ruling. We're not except implicitly ruling on the correctness of the municipal court decision.
When it got to the Superior Court, I looked at it, and I didn't argue in the brief here, but even if they review, as they argue, de novo, I still think you've got to find that the lower court, the trial court, abused its discretion in some way. I mean, if you're reviewing it de novo, you still have to, in my opinion, and please correct me, it's a bit confusing for me, but you still have to make a determination that there is the lower court messed up. They abused their discretion. They made a decision not based on law.
Can I ask you a
Applied
different question? Is the direct appeal of the municipal court conviction still pending in the Superior Court?
It is. Yes, it is.
And is that appeal focused on the speedy trial issue?
Judge, there are multiple issues in that case. And
do you remember if that's
I can't remember if that's one of them. There are multiple issues in that case, but that has stayed right now pending this decision here.
There was a request in the Superior Court to stay the municipal court proceedings in terms of the appeal, stating that if this court granted relief on the Rule 8 grounds, it would moot the appeal, which led me to believe Rule 8 was also an issue in the direct appeal.
And
Okay.
I've already submitted that appeal, and I'm sorry, I don't know if I have a copy of it with me here today. So I did want to clarify something, because there was a bit of a, there was a sound of, there was a sort of disturbance in the brief of the reply brief of the defense about me citing Vasco. I'm clear to you judges here today that obviously the special action was filed a week before the trial. Okay, I understand that this case does not come to you, as I note in the brief, as in Vasco. Okay, but I still think it's important. Based on the it's a very unique case. I think you'd have to agree. I think that, based on the circumstances in this case, I still think Vasco arguably can apply because of the element of prejudice. There's really been no showing of prejudice, and we certainly know that even more today by the argument that, hey, we're going to sit on that right and see what happens, and we might even be prejudice our client if we notify the court that, hey, the time's getting close. What are you doing? You set the trial date too late. I think the case law is important to review. It reflects how important it is, judges, to let somebody know beforehand so that it can be cured or corrected or fixed. And that didn't happen here. So there's no prejudice to the defendant. He was not in custody. They really can't argue anything. They argue in the lower court, I think, that he spent money on attorney's fees and his professional reputation. But every defendant that has the means spends money on attorney's fees. And if you're a professional, getting arrested for a domestic violence offense can affect your reputation. That's not the kind of prejudice that the court looks at when determining whether or not to factor that into this argument regarding speedy trial. I have 33 seconds. I appreciate your time, and I hope I was able to adequately explain the state's position in this case. We'd ask that you find that the defendant's rights to speedy trial were not violated. We concede that 180 days passed, but we do not concede that there's a violation of rights in this case. I appreciate your time.
Thank you.
Thank you.
Well, Judge Downey had expressed concern on several occasions during the oral argument of the problems with the record. And I think that Mr. Yeager's remarks clarify that, and I think this is also in the oral argument before Judge Carlisle, that the record was that all three missed it. Okay, and all three probably had duties to catch it. All three missed it. The explanation, you have an experienced judge, an experienced prosecutor, and a relatively new associate. The associate offered it as an excuse that he came across this and he's doing research on other issues, and then the record reflects it clearly. Said, well, I find that hard to believe. But the record is clear that that's what was said, and why he would find it hard to believe that Mr. Smith missed it, but not hard to believe that he missed it, or that the prosecutor he has frequent dealings with for the last 10 years missed it, I don't know, but that is what he said. But so there is a record as to what happened and what explanation was offered. But the one thing I want to leave you with is the Tucker Court and their statement to this effect, which I think is really dispositive of this case. But when there are no intervening delays between the event that triggers 8.2 and the expiration of the 8.2 time limit, the accused need not demand compliance with the time limits. Well, he didn't demand compliance. He said he missed it, but he need not demand compliance. Unlike the Sixth Amendment, wherein the time limit is specified, Rule 8.2 is quite explicit about the time within which the accused must be brought to trial. If nothing interferes with the running of the 8.2 period, which it's undisputed in this case, nothing interfered with it, the accused should not need to visit the courthouse every so often to remind the court to check the countdown. That's exactly this case, and whether he missed it or not, it wasn't his burden under this circumstance. It would have become his burden if he had filed motions to continue the trial or sought to waive time. but it wasn't Mr. Smith's burden under these circumstances. On that, we think there is an adequate record to conclude that Tucker applied here and that the speedy trial limits were not observed. Let me see if there's anything else I want to add.
I had one question that you could probably answer that Mr. Yeager wasn't sure about. Is the direct appeal, has that also raised the Rule 8 issue on appeal?
I was trying to pull out a piece of paper to answer that question, and I think that my recollection is no, but I really don't want to be held to that because I would have to look at it again.
That's fine.
All right, thank you.
Thank you.
Thank you.
Thank you to both of you for your argument and for your briefing. We'll take the matter under advisement and issue a decision in due course. Now we will recess to allow the next case to set up.